be there.
Okay.
Good afternoon, Judge Moshoana.
Good afternoon, DCJ.
Are you well?
I'm very well.
All right. Are you comfortable? Can we start?
Yeah, sure.
All right. You're a labor law expert. You quite apart from your practice in that area of the law, you hold a number of academic qualifications in that field.
Yes.
You started with a BProc, then you did an LLB, and thereafter you obtained a diploma in labor law.
Yes.
And you went on to get a diploma in corporate law.
Indeed.
And you obtained an LLM in labor law.
Yes.
And you are currently doing an LLD in mercantile law.
Indeed.
How far is that process?
Well, it is at a point where I am finalizing my thesis. I'm on a chapter 4 of my thesis. Having gone through the oral examination and being approved to write the thesis. Yeah, so I'm on chapter 4, and hopefully, now that I'm on long leave, I might be able to finalize my chapters and see what happens next year.
Oh, that sounds very promising. All the best, and I take my hat off to you. I don't know how a sitting judge can do what you do, find time to study on the side as well. I couldn't do it.
Yeah, I'm told it's called sacrifice.
Of course it is. You've been, well, first you practiced as an attorney for about 22 years before your elevation to the bench?
Indeed.
What kind of work did your practice conduct?
Literally everything, I would say. And I still recall that 1995, thereabout, there was this Legal Practice Act or some act that allowed practitioners, particularly attorneys, to appear in the High Court. So I was fortunate to be amongst the very first, and I did a lot of appearance in the High Court, and I did a lot of appearance in, of course, the Labor Court, the Labor Appeal Court, and the Supreme Court of Appeals.
So it was a general practice?
It was a general practice, I would say.
You acted at the Labor Court for quite some time before you were permanently appointed. Is that so?
Yes, indeed. I was almost called a permanent acting judge because I think maybe my mistake was to afford the 3 JPs that I worked with the whole term instead of just giving them a month as others would do. So I've always been in the Labor Court for a term since the time of the current Chief Justice, the Honorable Zondo.
Yeah. And I understand that you have about, well over 300 judgments out there, written judgments, that is.
Yes, I almost fainted when I saw that number because I didn't know. I never had an opportunity to count that, but it sounds right. I mean, I've been on it since 2007.
Yeah.
So it sounds correct.
Yeah, it does. Well, the fact that you've been at it since 2007 is no guarantee for anyone to produce, to be prolific. There are a few of us who've been on the bench for some time with not much to show. So.
Yes.
And some of those judgments have been upheld by the Constitutional Court.
Yes.
Okay. At first blush, your application form seems not particularly informative, and it's only when I was just going through each page that I found at the back, nestled at the very end of the form, a note which indicates that you actually sat in the High Court. You've not just been a judge in the Labour Court.
Yes, indeed.
You did a full term last year
Yeah, I did a full term last year.
in Pretoria.
Yeah, in Pretoria.
What range of work did you do whilst there?
Well, literally, I did almost everything. I even thought maybe I'm being punished by JP Mlambo because I did from criminal appeals, civil appeals, full court, special motion, urgent, and unopposed, liquidations, all the tutti, I would say I have done.
Right. Did you get an opportunity to run a trial, civil or criminal?
Yes, I did a civil trial.
Not a criminal.
No, I only dealt with criminal appeals.
Okay. The Law Society takes the view that you should spend a little bit longer in the High Court in an acting capacity before you are permanently appointed. Would you wish to comment on that?
Yeah, well, I was taken aback a little bit, and I read that part almost 3 times, and for some reason, and having been listening to the interviews, it appeared as if it was a standard letter that would be churned out. But in all honesty, it seems to me that the Law Society did not take into account the fact that the Labour Court is a superior court. And it has the same status as the High Court. And having acted and also sat in the Labour Court for 6 years, I don't know what more could prepare me much more better. Particularly the Labour Court is one of the busiest court, particularly in Johannesburg. And I see my JP is here, he can confirm that. So one asks himself a question, what more experience would be required? Because if you're an acting judge, one thing you are after is to understand how to run a court. So I have run a court, I've run a motion court, I've run an agent court, I've run a trial court, and the principles are the same. So with due respect to the Law Society, I do not believe that that is a consideration for the purposes of my candidature in this city.
Yes.
I hope, I don't want to be long, but I hope I've clarified my position.
That answer suffices, at least for my own purposes. You have not listed any reserve judgments, so I take it whatever leftovers you may have are well within the acceptable norms.
Yeah, unfortunately or fortunately, I don't have leftovers. I'm enjoying my long leave.
I envy you. All right. One last thing from me. The GCB makes a comment, they raise a concern that since your appointment to, well, your elevation to the bench, you have not been involved in any community work. I'm not...
Yeah, I've seen that, and probably I ask myself what form of community work would a judge be involved in. One of my friends will always, when he sees me at weddings, he will say, you know, judges are not supposed to be with people. They're supposed to live in a mountain somewhere because of the work they do. But it seems to me that they had not obviously taken into account the community work, I would call it, that I have done before elevation. And the organizations that I belonged to before elevation. All of that I consider to be part of my community work. And additionally, I would say, and I think Judge Mlambo will bear me out, I was involved in giving a lecture for the aspirant women judges in my capacity as a judge of the labor court. So that I also consider to be sort of community work.
Yeah. All right. Well, you get no judgment from me. I looked at your papers and I saw that you have a few young kids
Yes.
who have been studying at breakneck speed whilst churning out good judgments. So I'm not sure what else is expected from you.
Thank you very much, DCJ.
All right. We'll stop here and give chance to the other commissioners to put questions to you.
Thank you very much, DCJ.
JP Mlambo.
Thank you very much, DCJ. Good afternoon, Judge Moshoana.
Afternoon, JP.
And is it correct that when you came to act and your presence here today is as a result of discussions between the two of us?
Indeed, it is correct.
Thank you. The DCJ has already mentioned you acted for a full term in the High Court and you were thrown in the deep end.
That's why I did mention that I thought it's a punishment.
Well, you are a judge. You've been a judge for 6 years, so there was no need to take the precautions one takes when one appoints acting judges, isn't it?
I do appreciate that, JP.
Yes. And I think your spreadsheet appears deceptively small, but simply because it just refers to the High Court exposure.
Yes.
The 9 weeks you spent there. You've been a judge for 6 years. You've done all sorts of work that a judge does, isn't it?
That's correct, JP.
Especially agent court, opposed motions. And I see you had a full court special motion whilst acting in Pretoria.
Yes, indeed.
You wrote that judgment.
I wrote a judgment and I also wrote a dissenting judgment in one of the sittings.
Yeah. So any hardship, challenges you found doing, because you had a full judge's load. The only thing I didn't give you, and I would have taken the criticism that I wanted to kill you, had I also added opposed motions. I didn't. But in all the work you did, what's your assessment based on your experience as a sitting judge in the Labour Court?
Yeah, no, look, I did thoroughly enjoy the work at the High Court, simply because of the diversity that comes with it. But in terms of legal principles, the workload, I would say that it's almost similar to where I come from, which is the Labour Court. You would know, JP, that you've been at the Labour Court yourself. You know that it's a national court, and with a little number of judges, we do a lot of work. So it was not particularly challenging. And I can relate that during the time of the CJ as the judge president of the Labour Court, we never used to have a dedicated agent court. When you do motion court, you also do agent court. And on Wednesdays, without fail, you will leave the Labour Court after 7, after 8, because that's when you would do all sorts of unopposed and also agent court. So I would say I got used to the pressure.
I see.
Yes.
So, based on your experience, and I can confirm, you responded to my letter that I write to all AJs that when you leave, give me a report whether you owe me anything. And you proudly said to me, I don't owe you part heads, I don't owe you judgments.
Yes, indeed.
Yeah.
Indeed.
That's based on your experience as a labor court judge.
Indeed, I would say so.
And you feel comfortable that you'll be able to fit in the role of a high court judge.
Yes, I think I would transition smoothly. And I like the way the GCB puts it. It's actually a transfer because I'm just moving from one high court to another. But unfortunately, this process has to happen.
Yeah. Well, we all went that route.
Yeah.
We started there. There are judges
I know,
in
I
all
know,
the divisions who started in the labor court. Yeah.
I know.
Thank you very much, DCJ. I've got no further questions.
Thank you, JP. Premier? Are you there, Premier? Okay, we'll cycle back. Minister, do you have any questions for the candidate?
Yes, this is Jim, and good afternoon, Judge Moshoana.
Afternoon, Minister.
Yes, my question relates to the matter of Solomons. I see it is still on appeal, but there's a judgment on Mahube versus CCMA,
Yes.
where JP has described your decision to not to grant rescission as reason defied.
Yes.
I'm not sure with the limited scope you have, because the matter is on appeal, are you able to comment on this? Because it's also an issue that the GCB is raising, that it has raised serious alarms and consternation within the labor law community.
Okay. Yes. Yeah. No. You're right. Obviously, if the matter is subject to an appeal process, one would not want to comment on the principles that arises in there, because another court must have an opportunity to apply its mind. Look, the Solomons matter, just in brief, I would say I'm too surprised to hear that there's some consternation around. It just turned on the interpretation of a Section 138(5) of the Labor Relations Act. And in my own interpretation, which obviously differs to the interpretation of the JP in another matter, I consider that to say a dismissal of a matter without hearing the merits is a bit harsh. So the appropriate way to look at it will be to say, strike it off and so on. But the higher court, which is binding on me in my capacity as a labor court judge, looked at it differently. So we'll have to wait for another panel, if there is another panel that would consider interpretation.
Okay. Maybe other commissioners will take the point further. Yesterday, when we were interviewing the judges of the Labor Appeals Court, the JP was asking them that the matters they are handling and they are dealing with, and I'm now extending on the point you are traversing with the JP. And although it's in the labor court, but with the developments of labor law, it looks like those matters transverse now beyond just labor. They sometimes find themselves dealing with administrative law, insolvency law, and so forth. And I thought, as you are dealing with the JP, that you are only dealing with the matters for Gauteng High Court and so forth, what you have dealt with in the court, on the basis of the criticism that you are a labor law judge. I thought you will expand on that and tell us what is your view. Is it your view that you, in the labor court, you are no longer only dealing just purely labor, there are other matters that crops in as we deal with these complex matters that sometimes arise in the labor court.
Thank you very much, Minister. I will preface this by saying, in one conference that I attended, Conference of Judges, one of the High Court judges, when I introduced myself and said, no, I'm in the labor court, he says, oh, you the court that deals with only one contract, which is a contract of employment. And I said, no, you're mistaken. But nevertheless, this is the view that is held out there, that the labor court is very confined. But it can't be so. The starting point would be that Section 23 of the Constitution talks about fair labor practice, collective bargaining, and all sorts of things. The labor court deals with constitutional issues. The labor court deals with administrative law. The labor court deals with contractual law. The labor court, to a certain extent, would deal with what you would call a criminal work, because we deal with contempts. Those employers that are refusing to comply with the awards of the CCMA or even the orders of the court. There's an element of civil crime of contempt. So it is, as I said to the JP, it is no justification to my mind that you would say the labor court is confined, and as the DCJ at the beginning said that I'm a labor expert, but that's the view that is held there, out there rather. As the labor court, you are exposed in almost the same way, I would say, or even much more than a high court judge. So I wouldn't subscribe to the view that the labor court is only confined.
Yeah, thank you, Judge. Thank you, DCJ.
Thank you, Minister. JP Wakely. JP?
Thank you, Judge. Sorry. Thank you, DCJ. Judge Moshoana, good afternoon.
Afternoon, JP.
I agree with everything you've said so far. I think there is this belief amongst people who don't know, who haven't practiced labor law, that labor courts are courts who are dealing with one-dimensional stuff, dismissals, unfair labor practice. If they will come there, and especially if judges from the High Court come there, they're sometimes extremely shocked at the divergent issues we have to deal with. You know, recently and over the past years, we have judges from the High Court who've come to act in the labor court. And when they left, they said they've learned so much. So you don't feel bad about anything what people say. You are perfectly fit to go to the High Court. The question is, do I want you to go there? No, that I don't want you to do. I can assure the people here that, and in fact, I don't have to say anything. It's in the reports, and the Bar Council report, I think, says that a very competent and hardworking candidate. Absolutely correct. I think the hard-working part and competence is absolutely right, because you have been there for years, and I don't think you've ever left a term with a reserved judgment. And you're quite right, you hear matters late in the evening. If you're not hearing matters, you're actually working on a judgment. So sitting here, I'm not sure if I'm going to vote for you, but you deserve, and I'm pretty happy to say that you're one of the hardest working judges. The only issue is one pattern that's what I want to ask you is, in your questionnaire, in the very last question, I think, you've suggested that you still own shares in the law practice. I think that's a bit problematic. Hey? Is that correct, or did I read it wrong?
Oh, yes. Well, I suppose that maybe I didn't put it much more clearer. in terms of the interest. I said when I left practice, and I'm sure it could have happened to you as well, JP, that you will leave certain things, and the partners will say, no, once we get money, we'll pay you off, and so on. So it was in that context, but it is not really shares of any interest that I will always follow up and want to know what is happening.
I think you just need to sever that.
Yes.
Thank you. I have nothing further. Thank you.
Can I
Well,
just, it sounds like you are going to follow up on this point.
Yeah, I was.
I wanted to follow up with the minister, but I'll come after you.
Okay,
Mr.
it's fine. Follow up on the minister and I'll come after.
Yes, Mr. I think you should go first.
Okay,
I'll definitely
I was
come
just-
after you.
I was just going to clarify a little something arising from what JP Wakely said. As I understand it, it's perfectly permissible for judges to purchase shares and stocks like all
Yes.
other citizens. We do that as long as you declare what
Yes,
you're
I
supposed
have.
to declare in terms of the law.
Not in a law firm. It's in a law firm.
Oh, in a law firm, I missed that bit. All right, I see where the problem might be. Okay.
Yeah. Okay. Okay.
All right, I withdraw my defense. Advocate Ngaitu.
Yes, well, Judge Moshoana, I think now that this point of you having a financial interest in a law firm or potentially having one has been raised, I think it's unfair for you to leave it hanging because the public might think that you have a financial interest in a law firm, which would be wrong for a judge. What is the actual position so that we don't live here thinking there's something wrong?
All right. Yes. As I have explained, when you get elevated, you obviously fold, as it were, your participation in the law firm. And then you will sit around and say, look, we believe this firm is worth this much, and now that I'm leaving, it means you guys are owing me the X amount of money. And then they would say, we're going to continue with the practice, because effectively, in terms of the rules of the Law Society, I would be their practitioner, unless if I practice in a partnership, as and when I leave, I leave as an attorney for the purposes of the Law Society. But from a business point of view, my remaining partners may decide to continue with the business, and then at that point you would evaluate the business and say it's this much, and they always give you an undertaking that whenever we get money, we'll pay you out in terms of your value or your worth at the time. It's not like then it continued that you will have some form of shares in the company. It's effectively a debt. It's an acknowledgement of debt, if I may put it that way.
DCJ, can I
But
follow
what are
up?
the actual facts? I mean, I'm sorry, I don't understand. You've been a judge for 6 years, and you used to be a partner in a law firm. What's the actual factual position? I mean, you've divested, you are owed money, it will be paid. I'm not understanding what the factual position is.
Yes, the factual position is, at the time, and I'm talking 2016, 2017, thereabout, when I left practice, the practice continued, and the remaining partners said, for what is, if you were to sell this company at this point in time and take everything and go to the bench, it will be X amount of money. But because we want to continue with the practice, we will undertake to pay you that value that if you had decided to sell the firm, you would have pocketed for your own purposes before you get elevated to the bench. So those basically are the facts.
Can I follow up, DCJ? I think we need clarity here. When you look at the Legal Practice Act, because now we are no longer dealing with the Law Society.
Yes.
When you're looking at the Legal Practice Act, there's a provision there that allows practitioners to incorporate their businesses, all right? And again now, the Companies Act allows what we call personal liability companies. Now, I want to ask a direct question. The firm that you are part of, is it a partnership, as we understand a partnership to be in terms of company law, or is it a personal liability company wherein there are directors? And if there are directors, are you one of the directors? I think let us clarify
Yes.
that particular aspect.
All right, thank you very much, Commissioner. The company is an incorporated PTY, as it were. I think the Companies Act allows law firms to
So
incorporate.
it is a private company, because if you
It's an incorporated law firm.
okay, let me try to assist, because the thing is, there will be a public company, there
Yes.
will be a private company, that will be a PTY,
Yes.
and there will be a special company where people like lawyers, accountants, all
Yes.
those kind of people will be, which is a personal liability company. In other words, the directors are held jointly and severally liable with the
Yes.
company in that instance. So what I'm asking you is, the firm that you are part of, was it a personal liability company or even a private company, a PTY? Or was it a partnership in the true sense of the word as we used to understand them? And are there directors? And if there are directors, are you one of the directors? I think that will provide
Yes.
us with clarity.
All right. I'm not one of the directors. I resigned as a director as soon as I got elevated.
So the other directors just owe you money from your participation when you were a director?
Exactly,
Okay,
that's
no,
the
thank you very
point
much,
I'm
DCJ.
making. Yes.
DCJ, I
Then
actually
your,
was asking a
your
different
declaration
question.
in the questionnaire is misleading, Judge Moshoana, because you categorically say directorship in my law firm, which seems to indicate that you very much remain a director there, and then you speak of remaining directors.
Yeah, I'm trying to find it. I
It's
don't know
at
what page is
it's
it,
at
but
it's at page 13 of the bundle.
13.
Yeah.
Yes, and maybe,
Sorry,
Whilst you're, we
Judge
get to you,
Moshoana,
Advocate
Judge
Ngqoto.
Moshoana, if I could just, as I understand the situation, and I think you asked me advice years and years ago, is that you sold your interests in
Yes.
the law firm.
Yes.
You've divested from any interest in the law firm, but they haven't paid you for your share. They owe you money, and that's being paid off. So it's really a debt. What my problem was, it's phrased very badly here in your questionnaire. It says, I own shares. You own no shares, they owe you money.
Yes.
Isn't that what it is?
That's what it
So
is.
I have a problem when you say I had an interest. You have no interest. They owe
No,
you
I
money.
have no interest.
A law firm owes you money. That's what it is. isn't it?
That's what it is.
Thank you.
Perhaps it didn't come out as clear as it should.
Thank
and
you.
I agree and I accept that perhaps the reader would be misled and think that I'm holding shares. Our directorship in that firm, no. It's simply a question of being owed money.
To
yes,
you, Commissioner Ngqoto.
yeah, sorry, yeah, I think, sorry, someone, okay. I'm happy to consider, I just don't want, I just want to finish the point I was pursuing because it then got sidetracked with this issue of directorship. My point is not what is the corporate form. I understand there can be different corporate forms. My point is whether you have an ongoing financial interest in a law firm 6 years after you became a judge. That's my point. And I want to get that out of the way so that I don't leave the room believing that Judge Moshoana still has a financial interest 6 years after he became a judge. And that will continue when he becomes a judge of the High Court.
Yes.
So it's not the structure, whether you've resigned as a director or not, that's up to you and you've declared. It's the ongoing substantive financial interest.
Yes, I think the simple answer, as the JP of the Labour Court put it and clarified, I hold no interest. I only wanted to make reference to what is still being owed, and perhaps out of caution, I had put it in that way. But effectively, I hold no interest at all, if that's what you're after.
No, Justice Moshoana. I still have a problem because the answer I understood you had given initially was that the decision or the agreement among the directors was when the firm is sold, we need to agree a price at which it will be sold. Or maybe then, if I've got that wrong, I'm terribly sorry. But maybe you can then take us through the actual steps of this nature of this relationship.
Yes, I'm going to repeat it. I said, at the time when I got elevated, I was practicing in an incorporated law firm with a number of directors. And then when I had to leave, I said, look, if I was the sole director in this firm, what will happen is that I will just simply sell this company and then pocket the money and move on. But because you want to continue with the practice, the evaluation of the practice, not the sale, the evaluation of the practice is standing at, remember the figure was 3 million at the time. Now, as a 75% shareholder at that time, it means that the remaining directors would owe me a certain amount of money. And that's how it was concluded.
Yes, but how come, because you said it's not a debt. In other words, if you had said, I'm selling you this, but you have no money to pay me now. You said it was a debt. Or I'm not understanding the relationship. Did you sell your 75% to them and there's a sale agreement, but they are yet to pay you for that?
Yes. Yes. There was a sale and then they yet to pay because they didn't have the money at the time.
And then what's your explanation then for the declaration? Why is there confusion with the declaration?
Well, he did say that it's clumsily phrased.
Yes.
And that's,
Yes, I apologize. You did in fact ask that question,
Yeah.
DCJ. All right, let me stop
Are you satisfied then?
I've got the answers, DCJ.
Okay. Do you still want to follow up, Commissioner Lerotor?
Yes, DCJ. Just as an aside, after 6 years, the debt has prescribed.
When the debt is acknowledged, my little understanding of the law is that it still remains and they have acknowledged the debt.
Commissioner
Yeah,
Nasious?
CJ, I think I'm not satisfied with these answers but I think there's no more we can go beyond so, but I'm really not clear about this. It seems an endless debt. We don't know. The contradiction, I understand you explain, but now you say there's a sale, and it is endless. So I have a problem. I just want to draw that to your attention. I
Yes.
will argue about this matter at the
Yes.
deliberation. I'm not happy.
Thank you, Commissioner. I do appreciate your concern, and probably I do not understand what is meant by an endless debt, but it is a debt that remains unpaid. So I don't know whether that's what you mean by endless debt.
The point is you left, when is it, 2016 or 18? But now you declare it as an interest, but to change, explanation to say, no, this is a debt. It's some years thereafter. When is it ending? What is happening? Because it means if you come back next year, you'll still be having this. I don't know. I don't have facts about this. That is my problem.
Yeah. Look, I can't take it any further than what I did in relation to the questions that emanated from various people.
Well, Commissioner Nyambi?
Thanks, DCJ. Is the very same point, but I want to put it differently. As an experienced judge of the Labour Court, the unfortunate part is that as a commission, you'll be having deliberations where you won't have that opportunity to clarify it. With the engagement, after the questions asked, do you still have the same view, or you have something that you can clarify to assist us so that when we are not part of us, we can be able to make sense and have a better understanding? Because the more we're explaining it, is the more we get confused. And if I look at the declaration in terms of what we have done in page 13 now, what is the status of what is in page 13? What is the situation currently? And the more we ask questions, the more we get confused. So it might disadvantage you if you are not clarifying us properly. So that is why I'm appealing that maybe if you can have a parting shot after the engagement, your view about what is confusing us.
As I said, and I think if there is any level of confusion, it is cleared by the fact that I had said categorically that I don't hold directorship in this firm. And all I meant to convey was to say that for some reason, maybe somebody may say, look, I come across a sale of shares and you still have an interest in this company. I thought I would explain by saying, look, I'm still being owed money. But the answer I have given is that I hold no directorship. I've been a judge since 2017. I have not had any interest in the law firm except for the fact that, acknowledging the fact that they owe me. So that's all I can say, and that's what I wanted to convey.
In your view, everything is still in order. You don't see anything wrong.
In my view, everything is still in order, and I do not see anything wrong, particularly because I have already mentioned that I hold no directorship, and I think maybe the confusion as it is written, it's written cryptically, but it sought to convey something different.
When you are saying everything is in order, you're still referring to that page 13, that what is in page 13 is still in order. We must consider it as is.
No. Page 13, I've tried to explain what it means. So I would want you to take what I have said, it means.
Thanks,
or what
DCJ.
I sought to convey.
Thanks, DCJ.
Commissioner Singh?
Yeah, thank you, DCJ. You know, that's the point I wanted to raise on this. But I cannot agree that everything is in order, Judge Moshoana. I think everything will be in order if you can assure us that if you are recommended for appointment, you will immediately divest yourself of any interest in this law firm and also clear the ambiguity that exists, because we understand what we read. And what I read here is I still hold shares in the practice. I mean, that's what I read, and I understand that to mean you still hold shares in the practice. So are you prepared to divest yourself, if you are recommended for appointment, of any interest that you may have in your previous law firm? And I think a simple yes or no will help us in our deliberations.
Yes.
Yes.
Yes, simple answer is, to the extent that there's just lingering misunderstanding, I would simply disinvest, if at all it creates the impression. But I wanted to mention that I did state that the remaining directors were in the process of buying the shares off. So perhaps I should have just clarified that point much more further, but that's what I wanted to convey. So to the extent that it is required, and I think you should take it as my position that I will have no interest with this law firm.
No, thank you. But you see, the issue I have with the remaining directors who are in the process of buying the shares off, as raised by other commissioners, DCJ, it's 6 years. It's now 6 years. But let's leave it at that, and now that we've got this assurance. But just to JP Wagley, through you, DCJ, they say one man's gain is another person's loss. So I'll leave that thought with you. Thank you.
Thank you, Commissioner.
A follow-up there,
Yes,
DCJ.
Minister.
I think for me the point has been canvassed in terms of the time period and all that. I just want you to give insight to the public, Judge. This transition from running a firm and being called into the bench, how will you describe it for you? Because for sure, you were running a lucrative practice. You must now come into the bench with a different kind of dispensation. What motivated you to decide to leave practice and to come to the bench? And how do you describe this kind of a transition?
Okay, thank you, Minister. I think I was asked that question when I first came for the interview. I seem to recall that one of the commissioners said that I took too long to go to ascend to the bench because of having acted for almost 10 years. But the reason I heeded the call is at that time, I felt that I'm ready to provide my service to the judiciary. I wouldn't comment on the fact that I was running a lucrative practice, but granted, maybe I was, but I felt the need that there is my services are required at the judiciary. And here we are, 6 years later, I have, in my mind, delivered for the judiciary, and I would want to continue delivering for the judiciary.
Thank you, DCJ.
Sorry, DCJ, I'm terribly sorry. I really want to come back to this point. Justice Moshoana, when I asked the point about sale, I understood you to say you've sold. When you answered Commissioner Nyambi and Commissioner Singh, you said you were in the process of selling.
Right. Let me clarify it. I was just referencing the part in that paragraph that it didn't come out clear that what I meant to convey was at that time, given the fact that the partners or the directors did not have the money, they were in the process of buying off those shares that I left in the company. So it is not like I'm saying there is another process. I'm simply emphasizing that what I wanted to convey may appear, although ambiguously, as you may argue, in that part of the record under 21. That's what I wanted to mean.
But then what's there to divest? Because again, when you said, responded to Commissioner Singh, you said you undertake that you will divest.
Yes, because as I understand it, Mr. Commissioner Ngogaitobi, I understand it that it creates, even if I have explained it, it still creates an impression that I still have an interest. And to the extent, and I think Commissioner Singh has put it quite cryptly, he says that to the extent that it must not leave an impression, are you prepared to do the following? And that's the undertaking I gave.
Chief Justice, if you can allow just one. I just want to check one thing. When you apply, we were applying for your position in the labor court. Did you make a disclosure similar to that, to this one?
Commissioner Nyotesi, yes. That's why I'm saying that perhaps the way in which it came out as if it's still in 2017. So I did disclose that aspect.
Okay, before I close the subject, I'm not sure you can take it any further than you have. We'll give President Molemela a chance.
Yes, just a last follow-up to clear my understanding. The deed of sale in respect of your shares was entered into at the time when you left the firm?
Yes, that's the 2016, 2017.
Thank you.
Yes.
So to close off, Judge Moshoana, what is at paragraph 21 of page 13 of this document, which is a public document, is incorrect?
It is incorrect, sadly, perhaps given the pressures of drafting these documents, sometimes you put it in a different understanding, but it is incorrect. What it meant to convey is simply that there is still something that is being owed from my old practice.
All right. Commissioner Bernard?
DCJ, maybe to follow up on President Mulamela's question. So as a result of the deed of sale, was a transfer of shares, form, or documentation completed? Or would you still be indicated on the shareholder of the company?
Is the question complete, or you still developing it, Commissioner Barnard? Before I answer.
No, it's complete. It's just, it is complete. Please answer.
Yes, no, indeed, there was a transfer of shares. It's just simply the money itself was not paid over.
Thank you, DCJ. Thank you.
I had not had hands for questions for the candidate, all the questions that have been asked related to, they flowed from JP Wegley's question. There were follow-ups. Any questions for the candidate? No.
But does that include? Does that include those who are on the visual platform?
I was still coming to the colleagues on the virtual platform.
Okay,
Do you have questions? Or is that you, Commissioner Dodov? Thanks for joining us. Do you have a question?
That's correct. Yes, I do.
Go ahead.
Good afternoon, Justice Moshoana.
Afternoon. Commissioner?
My question is based on the fact that you are currently a judge at the Labour Court and you are flying to the High Court. And if you are appointed to the High Court, it doesn't necessarily mean that it is a loss for the Labour Court, because the High Court also has a concurrent power that it performs in relation to Labour matters like the Labour Court in terms of Article 7 of the Constitution. Is this how you feel?
The line was too bad, but I'm not sure whether I got everything. Assuming I did, I don't see this transition as a complete loss to the Labour Court, and for this reason. The Labour Appeal Court would oftentimes draw from the judges of the High Court for the purpose of sitting in the Labour Appeal Court. So to that extent, depending on the arrangement between the JPs, I might soon hereafter, if I'm appointed, see myself back at the Labour Court, but perhaps at the Labour Appeal Court. So to the extent that it might be considered as a loss to the labour law community, I do not think it should be seen as such, given the possibility that may arise. Unless, if I didn't understand the question properly.
No, it's okay. DCJ, my line is bad. Let me go and sort it out. I'll participate in the next candidate, if possible. For now, thank you very much.
All right.
Thank you.
Thank you, Commissioner Dodov. Commissioner Wiman?
Thank you, DCJ. Good afternoon, Judge Moshoana.
Afternoon, Commissioner.
I just have one question.
Yes.
Related to your profile.
Yes.
Did you run for Law Student Council in the 90s? at Wits University?
Oh, yes. That seemed to be bringing up other issues in terms of where we know each other.
Yes.
Yes, I was in the Law Student Council at Wits University in the 90s, I think, early 90s or late 90s. No, I think early 90s rather.
Thank you, which inevitably led the basis for where you are today now. Thank you.
Thank you, Commissioner.
Is that it then, colleagues? JB?
Sorry, DCJ, I had gone out to pay rent, and I'm not sure if these questions were asked. Judge Moshoana, there are two comments made by the GCB against judgments that you wrote. You are aware of them. The first one is the Solomon's matter.
Yes.
The GCB says your judgment caused some consternation in the labor law community because the candidate held, well, they explained that you're aware of that criticism.
Yes, I'm aware, and I think it was raised
The
already.
question was actually raised by
Yes.
Okay, thank
JP,
you.
but for your edification, I will allow he is applying to your court in any event, so I'll allow him to
Yes.
answer again.
What I said through you, DCJ, what I said, JP, was I'm surprised that the GCB sees it as a consternation. It happens every time that the Labour Court would interpret a provision this way and the Labour Appeal Court sees differently. I don't think it should be seen elevated to that high level. But the matter, I was told by the minister, that is still under appeal. So it might well be that the Labour Appeal Court would come with a different or the same view. But the matter turned on the interpretation of Section 138(5) of the LRA, which in my view, the usage of the word dismiss in the LRA is very unfortunate, particularly in line with the Section 34 of the Constitution, that how do you dismiss a matter without hearing the merits?
Yes.
And
Okay, I think that's enough.
Okay.
I think, yeah. The other one, DCJ, forgive me if that was dealt with as well, but it's the Mohube matter, where the LAC said your judgment was reason defying. You are aware of that criticism?
yes,
Was that one asked?
It's related to that one.
Okay.
It's related to the Solomon's matter.
I see.
Yeah.
Okay. Thank you very much, DCJ.
Was that all?
That was all. Thank you.
All right. All right. Well, we're done with you, Judge Moshoana.
Oh, thank you very much.
The interview has come to an end, and thank you so much for making the time.
Okay, thank you.
You're excused.
Thank you for the opportunity.